We spoke about how those of us who spoke felt that we need to give a mediated settlement agreement a slightly higher status. And it should not be just an agreement, there should be something more. The points made, to sort of support that were that there are disputes being resolved. People will take mediation seriously, they will have confidence in mediation if we give it a better status than just an agreement. We felt that efforts were being made by the parties to sort out their disputes instead of going to courts, going through litigation. The purpose was the same, that there was a resolution or there was a solution to the disputes. And so we must recognize that there is a special value in this effort and in this outcome, and so it must be better than a settlement agreement. So when we look at the other side of the picture, can someone question it? What I had asked you all to reflect on was, should we allow someone to question a mediated settlement agreement after they have had a mediation and they've agreed?
Now, if the party discovers there is some kind of fraud involved, or maybe those things can be allowed, but on a genuine note, no questioning can be allowed. If everything is all right, but just for the parties who want to escape it, then no questioning can be allowed.
Okay. So yeah, that's an important point. Thank you, Mukta. I'm making note of all the points you're saying because I want us to look at it after we've looked at the laws, to come back to these points to see whether they are sufficiently covered. So Mukta makes a point that there must be some rationale. A person can't say, I don't want this agreement anymore, and so I want to challenge it. No, it can't be that way. There must be a reason, a reason or a basis for questioning it. And one example he gives is that it is fraud. If there is fraud, then the person should be able to question it. Any other point?
Ma'am, it is already mentioned in section 28. So those are the criteria on the basis of which this settlement can be challenged. So as Sandeep rightly said, the fraud, corruption, impersonate, and the matters which are not means mediable, or it cannot be mediated as per law, but it was mediated. So later on, it can be challenged by one of the parties. But ultimately, fraud and hidden facts and all those things are maybe the basis for non-agreeing to the settlement agreement.
Okay. So we've got more reasons or grounds when you cannot question a mediated settlement. Anything else? Anything more? Please, Venkatekrishnan.
Madam, but see, whether a mediator can be coerced or brought under undue influence.
Whether a mediator or a party?
It could be either ways, madam. A mediator or the party. I mean, I'm just talking, I'm just throwing up a question because of the thoughts that is coming in the mind.
Okay.
The party can be coerced or the mediator himself can be coerced. There's a possibility of it.
Okay, so undue influence, coercion.
Yes.
And that's the reason why the party enters into a settlement agreement.
Absolutely right. Because the writings that would come in the settlement agreement may be a reflection of some of these things that could be there.
Okay. So more reasons where, or situations when you can question it. Undue influence and coercion of a party. Coercion is using a threat or force.
Yes, kind of.
Yeah.
But ma'am, this point is missing in section 28. I was searching for this, but I tried to find out the meaning of impersonation also, but nothing was fit with this coercion and pressure and the threat.
Yeah, it doesn't fit in. Impersonation is, I think, if I go to the mediation as Hemangi, no one knows better, and then I sign a settlement agreement, then that's impersonation, as far as I understand it. There is not too much clarity, but what Venkatekrishnan said, undue influence and coercion is is not there. Yes. Yeah. Any other grounds? Yeah, Hemangi.
Ma'am, I think if there is a change in policy and it is not possible to execute settlement agreement, that can be challenged.
Okay, that's interesting. Change in policy where you're not able to execute the settlement agreement. Okay. Can you give an example so we can understand this better?
Right now, I can't. There is nothing in my mind. Just it is possible that after, at the time of settlement, there are certain policies adhering which we are agreeing to that terms. But if by law, by statute, or due to some government policies there is change, and we are not able to comply with that particular condition, then we can challenge or for seek modification in it. Like
Yes,
that.
that's okay. Interesting. Thank you, Hemangi. Let me give an example, and Hemangi can tell me if this is what she meant. I have a joint venture with a company with someone in Cyprus, let us say, and there are disputes, and then I agree that I will sell my shares in the company in India to the person in Cyprus. Before this can be undertaken, the government brings a law saying that henceforth no one from Cyprus can hold shares in an Indian company. Now, we cannot give effect to our agreement because
Correct.
of change.
Like that.
Okay, thanks so
Thank
much. Anything else? Are we?
Ma'am, on similar lines, the example you have given, like settling on an issue which is against maybe environmental norms. Because
Okay,
this happened, because I remember.
thank you.
Like
That's
some installation of something which is against environmental norms. Even though we settled, the MOFCC doesn't allow this. So
okay. So, can I say against laws generally?
yeah, yes, ma'am.
Okay, thank you.
Policy.
Policies. Okay. Okay, I've got that. Anything else? The
A
point.
settlement which is
Yes, Swati.
a settlement which is made on some unjust terms in the contract.
Interesting. Thank you. Settlement on unjust terms. Thanks very much for that, Swati. Because unjust according to whom? Right? That's the question that comes up. There is an expression called unconscionable that I think lawyers in this group will be familiar with. Unconscionable agreements. These are agreements that when you look at it, you'll say, my God, who can agree to something like this? This is so unfair. Right? So I'm going to use the word unconscionable, unjust, unfair. Right? The reason why we are undertaking this exercise is we are now familiar with the mediation process. We are familiar with what happens in the mediation. We are familiar with the outcome in the mediation. And we are also agreed that this must have a separate status or an exalted status. I want us from our gut, from our heart, to think about where things could go wrong in the settlement agreement, where things can be a problem in the settlement agreement. Can we think of all these situations, and then we look at these policies to see if they cover it the way we have covered, what we've things that we've thought of. I also want, when people are making a point like this, that you can question a settlement agreement on this basis, for you also to think about what has been raised and see if you agree with it or disagree with it. So, any more situations?
And just one thing, I'm not adding to the situation. Just one thing. Suppose in most of mediation settlement agreement, both the parties are framing the conditions of settlement.
Yes.
Mediator is not writing the settlement agreement. But suppose party A and B, they have arrived on some settlement agreement and points, but they are unjust or they are some against public policy or like this. So ultimately, the mediator is also required to sign on that agreement. So at that time also, he can deny that this is against the law or this is impractical or unjust. So I will not sign that until unless he doesn't sign that. It will not be a settlement agreement and will not be treated as a decree of court.
Okay, so 1 second, I'm just writing it down. So a mediator is not supposed to sign off on the settlement agreement. Some rules say that they will sign off on the settlement agreement, but what the mediator does is to authenticate the settlement agreement in the sense that the mediator will say that, look, there is this settlement agreement. This settlement agreement was entered into after mediation. So what the mediator does is to say that this has taken place as a consequence of or following mediation, and that's all that the mediator says. But your point, the point that you raise, is very important. What is the responsibility of a mediator when the mediation is taking place? If the mediator finds that the agreement is against a law, should the mediator terminate the mediation? If the agreement appears to be very, very unfair even to the mediator, should the mediator stop or not do or terminate the mediation? Because you can't tell the parties don't sign the settlement agreement. What we can do is terminate the mediation. They may go find another mediator and sign it. They may just sign an agreement themselves or just implement it. But the process will not, or the mediator in sort of following their code of conduct, their ethics, should they, allow a settlement agreement to go forth on something that is very unfair or something that's against the law? That's a question he asks. What do others think? Or are there other grounds? Do you disagree with the grounds that have been listed so far? Hemaki?
Ma'am, one more thing there is in my mind. In between parties, if there is a change in circumstances, then we challenge it. For example, if there is settlement out of family court dispute, and again same situation or same circumstances are happening of abuses and all that, the party will challenge.
Give me the example once again.
For example, in family court settlement dispute, there is a settlement agreement in between husband and wife. And after some period, again the same circumstances of the like previous things are happening of abuses or some fights on the same grounds or some new grounds. Then the settlement agreement can be challenged.
Okay, this is again an interesting reason, but we need to think through this very carefully because change in circumstances is a very wide expression. So, if we can make it a little narrower, what kind of change of circumstances are we talking about? Then we should evaluate whether that's something that can come in. So, if you all can think about that, that will be good. Venkatesh, were you able to say something? Were you about to say something? No, okay.
Just a small means for my understanding of the issue. Under section 19, mediated settlement agreement, as you already said that mediator is basically authenticating the settlement agreement. The parties are still 1, 2, or whatever the number of parties may be. They are signing the agreement, settlement agreement, and the mediator is authenticating them. So can we consider that there is a layer of there is a layer of safety, security, or whatever you can say, that these agreements will not be against the law because a mediator is sitting there and he has some responsibility. So if there is anything wrong in that, he will not authenticate that. And until unless he doesn't authenticate that, it will not be treated as a degree of court and it cannot be implemented legally.
Yeah, I know. Yeah, so you're right. The mediator can say, I'm not going to authenticate it. My question is, to everybody, is can a mediator do something like that? Can a mediator say, I'm not going to authenticate it? That's the question.
Practically, I think he should in some of the cases. Like
Okay.
there may be cases where he should
say that I won't authenticate, right?
Yes.
Yeah, okay.
Madam, sorry, I didn't raise my hand.
But
okay, sir, you continue. Then I'll ask the question.
No, Venkatesh, sir. You continue.
Okay. I have a question on the other side. It so happens that I think it was in continuation to Hemangi Madam's question is, when I'm talking about a change circumstance, change circumstance, let us say either if I had to correlate change circumstance in an asset or change circumstances in the markets that is happening. And let us say there is a settlement that has happened. Usually this mediation period is for a period of say 3 months, and the situations in the asset have changed. Now, in such situation, the basis on which the or the mediator comes to know that this is something that has happened. Now, the mediator can always refuse in such situation if he is aware of it. Or the question is whether the mediator will still go by the actions of the parties, wherein he may not be, or the parties are thinking that they are not aware of it.
So you're saying there's a situation where the mediator knows a little more than one party.
Absolutely right.
And the parties are still, I mean, they haven't signed yet, but these are the terms that they're discussing. What is the responsibility of the mediator?
Absolutely. Or there is a change circumstance in the market. Let's say there is a sudden appreciation in the market on the price of a property has changed, where the fundamental dispute is on the property.
Okay.
Now,
And people are discussing on the basis of the earlier situation.
absolutely.
There is responsibility on the mediator to
Yes.
bring this up. Yeah. Now we are going into the territory of what is the responsibility of the mediator. Both what Vijayant and you are talking about is a situation where the agreement is not signed yet. Okay, and it appears that the agreement is either unfair or there is a huge change in circumstance which one party typically is unaware of, and that changes the very basis of that agreement. So let's assume that there is a couple who have a lot of property, and there are companies, and the husband controls the companies. In the settlement, they are discussing that the husband will transfer shares of certain companies to the wife. And let us say they are in the business of mining, and there is a ban on mining, and the wife doesn't know this, or there is nationalization of the mining companies, the wife doesn't know this. She's going to sign the settlement agreement taking these shares in the mining company, but these are going to be worthless. What should the mediator do? What do you think? Okay, so we are going a little off topic, but this is an interesting question that or issue that Vijayant and Venkatakrishnan have raised. So let's discuss it. So what should the mediator do?
Ma'am, mediator actually his roles will be neutral, but in physical cases we were told like sometimes we need to compromise neutrality for fairness. So he has to disclose the things for fairness.
Okay. Anyone else? Kya Keshav?
Ma'am, I think the mediator should stay out of it. His role is to facilitate. He can give some hint during the process of mediation, but it's not his job to disclose to the wife that so and so is the problem. And it's her responsibility to make sure that what is being offered to her is actually the worth that she is perceiving, or it's lesser or it's more. So I think he should stay out of it. He may give hint, but not get into it.
Okay. Himangi?
Ma'am, on similar note, he should be act as a neutral person. At the same time, in future circumstances also, we can't predict being a human being what will happen after 2-3 months. The same on the same line what Mr. Dekat was talking about. So we can't just keep on imagine that after 3 months or 2 months or 4 months what will happen, and or accordingly we will guide them that, and we will as a mediator take certain decisions.
Okay. Anyone else with a view? Krishna Kumar, I think you were going to say something. Was it on this?
Madam, when one party agrees to the settlement agreement, after the parties sign the settlement agreement, after 2-3 months, if one of the party knows that some facts are hidden in the settlement agreement, So can she go to the court for that? That was my question actually. Whether she knows the facts after the settlement agreement.
Okay, so there is either misrepresentation or suppression of material, of information.
Yeah, or some hiding facts actually.
Yeah. Okay, so that was another ground. Information. Okay, I've got that. So going back to the issue that Venkatrakrishnan and Vijayant raised, this is a really tough question. And I don't think I will be able to answer with a definitive this way or that way. But the point that one of you made, now I'm forgetting who raised that point. I think when we say neutrality, when we say fairness, when we say self-determination, when we say confidentiality, all of these are not separate items. They're not separate value systems. They're all connected with each other. And I think that's the point one of you made. What is the point saying self-determination if one party to the mediation is so sort of unfamiliar with things, doesn't know much, is less sophisticated, cannot even speak or is not articulate, cannot share what they want to say clearly, is frightened of the process, right? What are we talking about self-determination then? So you have self-determination, you also need fairness. Who manages this process? Is that person responsible for fairness in the process? I would think yes, but this is my opinion. It's my opinion. So when you say neutrality, I don't know what this neutrality means because all of us are political people. We have views on many things. We have biases about many things. We say we go into the mediation as neutral people, but I'm not sure that's true. I don't know how true it is. Because we may control our judgments, we may control our reactions, we may control our prejudices, but these are things, I think there is the tip of the iceberg, there is things that we are aware of and we control, but there are things that we are not aware of and we let that continue because we think that is, we may see a certain way in which a conversation is going and we may think that is okay, that's right, but we don't know what construct of biases and value systems that we have that is telling us that, this is a good way in which this conversation is going, right? So it's very, I think this neutrality is very elusive, very difficult for us to find what it is and to be that way. We often make mistakes and we must be sort of aware of it. And so neutrality feeds into, which is why when we talk about confidentiality and exceptions of confidentiality, some of the areas in which there is no confidentiality or there is a responsibility on the mediator to either terminate the mediation or to report this to someone else is because there is someone who is vulnerable, who is abused, because there is no equality there. That's where we throw neutrality to the winds and we say, or we throw confidentiality to the winds and we say, no, there is a responsibility to deal with this situation because the situation is so bad. So the law is recognizing it. So everything, it is not as if confidentiality is in this box, neutrality is in this box, fairness is in this box, self-determination is in this box. They all interact with each other. They are all on a scale and each interacts with the other, and then we get a sort of a framework for what we need to do at that time. So I think the points that both Vijayant and Venkatrakrishnan raise are important. And this is something we need to be mindful about. I'm not able to, I'm not saying anything with any category, with any sort of definitiveness, but I'm only conveying my point of view. It's my opinion that if this is happening, then I think there is some responsibility that the mediator should take, that they haven't signed the agreement yet, but this is the information. Either terminate the mediation, I don't know about informing the party about it, but possibly asking open-ended questions that could make the party reflect on this, especially when the party doesn't have a lawyer to assist them or someone else to assist them. That could be a way to do it. But I'm just speaking very generally, not prescriptively, because we don't know the whole situation. We're just throwing up some thoughts that we have. But this is my point of view. Anyone with a view on this who disagrees, agrees?
Ma'am, I agree whatever you said. And as I'm going means day by day, we are attending more classes. I think I'm coming to a conclusion that mediation is not a very easy process. At least for a mediator, it is not an easy, and you cannot just read few books or just go through the act and you will become a mediator. Arbitration was a bit simpler, I think, in terms of rules, regulations, and all those. There were some guidelines, at least. You have to go as per those guidelines. We had physical classes in Mumbai in this course, and we were having some jobs and roles and responsibilities for mediation while we were conducting mediation. So there it was taught that you should not put your facts and figures, and you should not lead the means mediation process. Ultimately, the parties have to settle them. Now, one more thing was there in arbitration. Sir told that the award should be such, it should be enforceable. One target should also be there that at least it should be enforceable. Otherwise, what is the use of the award? Now, in mediation also, if you are authenticating the mediation settlement agreement, so you should also go through the settlement, the terms and condition and all those things. And then you should authenticate that, keeping in mind that the whole process is basically to come to an agreement which should be enforceable, and your target should be that it should not be challenged as such. So
that I'm not able to agree, Vijayant, because enforceability is the responsibility of the parties. Let's assume, because it's dangerous territory to go into that. Let's assume the agreement relates to, say, some patent, some scientific thing, right? Some licensing agreement, which is on technology. I am the mediator. I'm not familiar with this, right? So I shouldn't be directing how the agreement is. So it's very dangerous territory. Let us assume I am an expert on this technology. I should be careful that I'm not imposing my way of how things should be. One is on fairness and what the mediator should do. The other is this I would think should be left to the parties. Anil?
Yes, madam. Even otherwise also, the enforceability mediator cannot ensure.
Yeah.
He can simply mediate and arrive at a settlement with the help of the parties. His role is facilitator. So for execution of the order also or agreement also, it is well within the realm of the parties, not for the mediator.
Yeah. There are some aspects which I think the mediator can sort of make sure, in the sense that if it needs to be if, let us say, it's a matrimonial dispute and the parties are agreeing that they are going to dissolve their marriage, they can't agree themselves. They have to go to the court and get it done. So, say, making, telling the parties that, look, there is that you need to take into account. Something like that, maybe some broad these things, yes. Some, formality-wise things, yes, you can. But otherwise, yes, what Anil says, I would agree that it's for the parties to take on that responsibility. Keshav?
During our physical classes, we were told that in the process of mediation, the mediator role is just that of facilitator. So even if the terms that the parties are agreeing is not favorable for one party, so the mediator should not be the one who should get into this. So I wanted your opinion on that.
Yeah, so it may not be favorable, or if the party is giving up some rights, waiving some rights that they have. Generally, yeah, I don't think the mediator has a role in that. But we are talking about situations of things being very unfair. Things being very not in balance. There is a huge mismatch in the balance, because some of the ethics rules that you see, for instance, I'm going to read from the IMI ethics rules. It says, in the mediation process, the mediator should terminate it if the agreement that the parties are entering into is unconscionable. That's what expression I was using earlier, or illegal. The mediator should terminate the mediation process if there is undue pressure exerted, power imbalance, exploitation. These are strong words, but the Code of Ethics seems to impose some responsibility on the mediator. Some people even talk about, this is particularly in the context of public disputes, environmental disputes. There is a person called Frank Sanders who does a lot of these disputes, and he says it is the mediator's responsibility in environmental disputes to make sure that the agreement is stable, is fair. All parties who might get affected by this agreement should be participating in the process. These are all responsibilities of the mediator, according to him. Other people take exception to it. They say, where is your neutrality if you take on these kind of responsibilities? So it's still a debate. I tend to think like Frank Sanders, but a lot of people disagree. Yeah. It also depends on the type of dispute, who the parties are. It all varies. Yeah. Venkatekrishnan, then Krishna Kumar.
Okay, I think it was Krishna Kumar. I think, sir, you can finish.
Madam, I think if the settlement agreement, you're talking about the environmental policy, if it is goes against the public policy, then the mediator should stop the mediation process, or it should not be continued actually, if it is going against the environmental policy actually.
Okay,
I
one
think
example is
that-
involved. Okay. That's yeah, that's
or any process going against public policy.
yeah. So, and as an example, you gave environmental policy.
Yeah.
It's a great point. You find all policy, like laws talking. You might have come across it in the Arbitration Act, challenge to the arbitration award on the ground that it is against public policy.
Public policy, correct.
The big problem you must have also realized is what do we say is this public policy?
Yeah,
Right? You
that's
must have heard the expression
that is another.
unruly horse, the court talking about it as an unruly horse. Right? Yeah, okay. So yeah, but it's good to have it, good to have this residuary thing. Venkatekrishnan?
Madam, in the event that you're seeing a foreseeable event, because coming from a valuer background, I always tend to lean on it. I'm seeing a foreseeable situation now, wherein you can always suggest the parties to make the agreement. And I don't know whether I'm right in saying this, whether you can always say that in the event of such changes that are going to be there, they can always bring in those aspects into it.
If it's foreseeable, okay.
It is foreseeable. It is very likelihood that is going to happen. Because tomorrow it should not happen that a mediation agreement is so tight-fisted that that agreement itself doesn't make any sense. So in such situation, like a change in policy or change in some circumstance and all that, which both parties, one point is somewhere a mediator's responsibility will be to make them aware, or how you're going to act in such situations, something like that, so that when they are drafting it, they can bring this point of it. I mean, I don't know, there's a
So I'm getting 2 points from what you're saying. The first is that it is the responsibility of parties to contemplate what is likely to be the situation and provide for it, because otherwise, according to you, the mediated settlement agreement will be like a tight grip. You will not be able to maneuver it. The second point you're making is that, I don't know if you're making it or asking the question, should it be the responsibility of the mediator to nudge the parties to think about what the foreseeable future is likely to be, what the immediate changes are likely to be, and to make provision for that in the agreement?
Yes.
Yeah.
Yes.
Okay, yeah, I think that's important. And therefore, the consequence would be that if something was foreseeable, don't now tomorrow question it on the basis that, look, there has been this change. Okay. So you're bringing a sort of a rigor to a lot of these points that we have discussed. For instance, public policy and things. Thanks. Anil?
Madam, according to me, there should not be any flexibility in the mediation agreement, because if flexibility is there or terms are loose, then that may itself enough to fail the mediation. There may be dispute about the terms and conditions. Terms and conditions have to be very specific. It has to be watertight and tightrope working, so that no
Agreed, sir.
dispute arises out of the mediation settlement.
That's right. So terms must be certain. So we're all talking. I mean, it's I'm getting so much from today's class. I have good notes from today's class from all of you. We're getting so many points. The thing is, how do we achieve this balance when we are doing the mediation? I think over time, with experience, we'd probably get there. But yeah, it becomes, if we have to take all of this into account, then it becomes, it seems like it's a very sticky place to be in for the mediator. It's not always like this. But yeah, thanks for all the points that have been raised. Any more on this? Any more?
Yes, madam, one thing. Mediation, theoretically, he is a facilitator only. The parties have to find out and work out a solution for the dispute. But during the last 15 years where I am doing mediation, I am following a particular strategy I can share with you. I do not know, theoretically it may be wrong, but practically it gives result. What I do before I go for mediation, I do the strength and weakness analysis of both the parties. When I am talking to party A, I talk about the strengths of party B and weakness of party A, so that he comes down and loosens a little bit and become ready for mediation. And when I talk to party B, I do similar thing in a different manner. And this is in the breakout room, so that they are not aware what I have discussed with whom.
Yeah.
Then I come to the common room. Common room, I ask them, make them free to talk to each other. Since I have already told them that this is your strength, this is your weakness, this is the strength of other party. So they loosen their attitude, they loosen their interest, they loosen their approach. And they come for a little bit forward to each other, so that there can be a mediation agreement. If required, I again go to the breakout room, and finally I find that this works and they agree to a common point. Because in most of the dispute, it ultimately boils down to money, as far as my cases are concerned. So the way we are bargaining while buying vegetables, in a similar fashion, things take place here. And generally the mediation is successful this way.
Okay, that's good. Thank you for sharing this tip. My only correction would be that you're not facilitating, you are evaluating. The mediation that you're doing is evaluating.
But ultimately, nothing succeeds like success. If we stick purely to the theory and we are not able to do even a single mediation, that is useless.
No, I'm not saying what you're doing is not theory, doesn't follow theory. There are different approaches to mediation. One is facilitative, second is evaluative, there is transformative, there is therapeutic. There are many types of mediations. The mediation, and again, they are not in separate boxes. You can do facilitative, then move on to evaluative, then come back to facilitative, right? Go to transformative. It can happen. Transformation can happen even without you intending to do it. I was doing a dispute where there was a certain sum of money which had to be distributed pro rata amongst all the creditors. If all the creditors had a claim of, say, 1 crore of rupees, the amount available for distribution was only about 33 lakhs, let us say. So no one was going to get their full amount. But within, when I say all the creditors, there were only 4 or 5 of them. Amongst the creditors, one creditor was a big company and to whom the bulk of the amount was owed. There was a small creditor who was not a very well-to-do person, was doing a single person business, making very small supplies. And we kept discussing and we said, this is how it needs to be. This is the norm, shall we all, how do we do this, etc., etc. And then the pro rata amount was fixed. Then this representative from this company calls me aside. He says, I want to speak to you separately. And I say, okay. Now, in all these meetings, these people have discussed what their difficulties are, what their problems are, what their issues are, what their expectations are, etc. So everyone knows a little bit about the other person's problems, what they want, what they need. He calls me aside and he says, in a private session, he says, look, we should be getting out of this fund, we should be getting about 23 lakhs, and that person will be getting about 50,000. We want to give away 50,000 or 20,000 from our fund to be given to him. Because 20,000 doesn't mean much for us, but for him it's life and death. It's a big difference for that person because he's poor. And so we reworked this calculation where this company gave up a little bit of their money to this man who was quite poor and who really needed this money, was in debt because the money had not been paid to him. His supplies he had not received money for. Now what I saw was a transformation. They were not thinking about themselves. They were thinking about the other person's problems, the other person's needs. This was a commercial dispute. It wasn't typically one thinks transformation is, in say employment, workplace disputes or, but it can happen anywhere. So what you are doing is evaluation. What you're doing is a mechanism by which you are, because you have the expertise in this area, you're able to assess what is the strong point, what is the weak point, and you're helping the parties see that. This is something I do, but I don't do it by telling them. I do it by asking questions, and again in a breakout, in a separate session. So we ask questions. It's called reality testing. And with that, we hope the parties will reflect on where things stand for them. Yeah. Thank you for sharing that tip. Okay. So shall we now go on to the laws and see what they say about when you can question a mediated settlement agreement? So we'll first look at the Ireland Mediation Act because that's a short one, so we can go over it quickly. And we go to section 11 of the Ireland Mediation Act. There are many, many more policies in different countries. It's worth reading it. We only have 15 hours, so I'm limiting it to some laws. So section 11 of the Ireland Mediation Act. Let me know when you've got it and then we can read it. Yeah, okay. 11.1, the party shall determine if and when a mediated settlement agreement has been reached between them and whether the mediated settlement is to be enforceable between them. 2. Notwithstanding subsection 1 and subject to subsection 3, a mediation settlement shall have effect as a contract between the parties to the settlement, except where it is expressly stated to have no legal force unless it is incorporated into a formal legal agreement or a contract to be signed by the parties. So the law says that if you have a settlement agreement, it's like a contract between you. But if there are requirements under the law that it must be registered or it must be stamped or it must be a contract in writing, then you must put it in writing for it to be an agreement. So it doesn't even require you to write that agreement. If you've both understood it, you both intend to, you're clear that you are implementing it, that's enough. Okay, but it's only that, it's only an agreement. Now we come to, can you question a settlement agreement, right? Para 3, it says, without prejudice to sections 8 and 8 capital A, I'm ignoring the information that are in brackets, of the family law, and subject to subsection 4, a court may, on the application of one or more parties to a mediation settlement, enforce its terms except where the court is satisfied that A, the mediation settlement does not adequately protect the rights and entitlements of the parties and their dependents, if any, is not based on full and mutual disclosure of assets, or is otherwise contrary to public policy. So this is in the context of any settlement agreement, but in particular we are concerned with, say, what is that? The maintenance orders or maintenance agreements that parties may make. So if the settlement does not adequately protect the rights and entitlements of the parties and their dependents, is not based on a full and mutual disclosure of assets, or is otherwise contrary to public policy, the court will not enforce the settlement agreement. So this will depend very heavily on what the laws are on maintenance, on supporting of children and spouses. And if the settlement agreement falls short of certain standards that that law tries to secure, then the court will not enforce it. We also see that it is otherwise contrary to public policy is an expression that they are also using. Right? What is of value in the public interest to that country? If it is not meeting it, then it will not be enforced. Then we look at B. It will not be enforced if a party to the mediation settlement has been overborne or unduly influenced by any other party in reaching the mediation settlement. Okay, so these were points that you have raised, and it's covered in this law. It's 10:25. I'll stop here, and then when we come back, we can go and look at the Singapore law and the Indian law. We'll rejoin at 10:35. Yeah, thank you. Or 10:30. 10:30. Thank you. Can we continue? We'll go next to the Singapore law. And again, this is in section 12 of the Singapore Mediation Act. So I had explained earlier how the Singapore law works. There is a system of mediator training, certification, and recognition. And the law says you can go to the mediation by these persons who are certified and trained, but you can also choose someone who is not a trained mediator to be the mediator in your dispute. In either case, it becomes an agreement, but in the case where the mediation has been done by a certified mediator, the parties are able to apply to the court to get the court to recognize this agreement or to review this agreement and to pass a decree in terms of this agreement. And that is in section 12. So section 12 says, where a mediated settlement agreement has been made in a mediation in relation to a dispute for which no proceedings have been commenced in a court, any party to the agreement may, with the consent of all the other parties to that agreement, apply to a court to record the agreement as an order of court. The application must be made within 8 weeks after the mediated settlement agreement is made, or such longer period as the court may allow. Subject to subsection 4, a court may record a mediated settlement agreement as an order of court if the mediation is administered by a designated mediation service provider or conducted by a certified mediator. The agreement is in writing and signed by or on behalf of all the parties to the agreement. And 3, the agreement contains such information as may be prescribed. So the first is that these are all sort of procedural and sort of semi-formal requirements for an agreement. So it has to be done by a mediation service provider or a certified mediator. And then procedural requirements, it has to be in writing. It must contain certain information. So for instance, one of the things that we put in our agreements, particularly in the court annex mediation system, is we say that this agreement has been entered into without any force, fraud, or undue influence. So certain standard things. So when a person sees that person, the hope is that it triggers in that person a sort of a reflection about, okay, is everything okay in what I have signed? Do I need to sort of reconsider something? So that could be a formal requirement. That could be what is prescribed in the rules on what a mediation settlement agreement must say. Then we come to subsection 4. The court may refuse to record a mediated settlement agreement as an order of court if the agreement is void or voidable because of incapacity, fraud, misrepresentation, duress, coercion, mistake, or any other grounds for invalidating a contract. So this is linked to the contract law that they have in their country. We started off having the same contract law because we were both colonies, but we've gone our ways as well. The subject matter of the agreement is not capable of settlement. I'm going to come back to this voidable. I will explain it in the context of our Contract Act when we come to our Mediation Act. But these are points that you have all raised. Void could be if there is a child who is signing the agreement. Void could be if the person did not have the mental capacity at that time to sign that agreement. Voidable are situations where at the time of entering into the agreement something is not okay, where your free consent is affected, your ability to consent is affected because there is a fraud you didn't know. So in these situations, you are able to say, no, I'm not going to go ahead with this agreement. This is what contract law talks about. We'll go into all of these in a little more detail, but that's ground number A. So if it is void or voidable, the court will not give it the insignia of the order of court. Second, the subject matter of the agreement is not capable of settlement. Again, a point that you had all raised. The term of the agreement is not capable of enforcement as an order of court. any term of the agreement is not capable of enforcement as an order of court. An example for this could be that if what they are agreeing is so vague that even if the court gives it as an order, the court will not be able to oversee it or implement it or enforce it. That could be one situation, right? The next one is where the subject matter of the dispute to which the agreement relates involves the welfare or custody of a child. One or more terms of the agreement is not in the best interest of the child. The next, the recording of the agreement as an order of court is contrary to public policy. We've seen that in the Ireland Act. We've seen it here as well. It is against public policy. And 5, a mediated settlement agreement that is recorded under this section as an order of court may be enforced in the same manner as a judgment given or an order made by the court. So in the sections again are linked. What is the status given to a settlement agreement, and then what is the oversight of a settlement agreement. If I choose not to take my agreement to the court or to get a decree in terms of the court, then I keep it as an agreement. It is subject to challenge that anyone could make on the ground that it is an agreement, right? Or it could be challenged under any other law where there are certain standards set under that law. For instance, if there are standards set about what would be provided for a child, then it can be challenged on that basis, right? If a law says that a property of a child cannot be disposed of without order of the court, which is the law in our country for certain for children of certain religions, and you've made this agreement to sell property or dispose of property of a child, and obviously you cannot enforce it because you've gone completely against the law, and that can be challenged under this other law which requires permission from the court, right? So this is the Singapore Mediation Act. We now come to our law, the Mediation Act 2023. So Vijayant had already pointed out what the grounds were that were on which you can question the mediated settlement agreement. He was talking about section 27
and 28.
And 28. There's also section 19 that we will look at. So let's look at 27. The two things are linked. It is also linked with the next topic that we will discuss, which is what are disputes that can be taken for mediation and what are disputes that are excluded from the mediation process. So these are three linked areas. One feeds into the other when one looks at how policy deals with these aspects. So 27, if we have it, of the Mediation Act 2023. Shall we carry on? Enforcement of mediated settlement agreement. A mediated settlement agreement resulting from a mediation signed by the parties and authenticated by the mediator shall be final and binding on the parties and persons claiming under them respectively, and enforceable as per the provisions of subsection 2. So if a person has signed the agreement, passes on, their children who inherit their estate, their properties, they will be bound by this settlement agreement as well. That is, the property will be bound to satisfy this settlement agreement. Subsection 2. Subject to the provisions of section 28, the mediated settlement agreement shall be enforced in accordance with the provisions of the Code of Civil Procedure 1908 in the same manner as if it were a judgment or decree passed by a court, and may accordingly be relied on by any of the parties or persons claiming through them by way of defense, set off, or otherwise in any legal proceeding. I should be able to say in a legal proceeding, I can enforce it by way of a judgment if the other person is not implementing it. If there is some case filed by the other person on same or related issues, I should be able to show that, look, this has been settled by us in this fashion. Or I should be able to say that, he's asking for so much money to be paid by me, but look, under a mediated settlement agreement, he's to pay me so much, so set it off. I could also say waiver, because if the person asks for something in that other case, I can say, look, that was something that we discussed and he said he did not want, he was waiving it, now he cannot ask for it again. So these are things that I can raise, as a response to any case that may be filed in relation to the subject matter that has been settled in the mediation. The next is section 28, challenge to a mediated settlement agreement. Notwithstanding anything contained in any other law for the time being in force, in any case in which the mediated settlement agreement is arrived at between the parties and is sought to be challenged by either of the parties, such party may file an application before the court or a tribunal of competent jurisdiction. So the first thing you will notice about section 28(1) is that this provides for challenge of the mediated settlement agreement by a party to an agreement. If a person is not a party to the agreement, this section does not apply to them, right? So assuming that my brother has gone and settled in a mediated settlement agreement, a family property, and I'm not a party to that agreement, I cannot question it under 28. I have to look at other avenues of questioning it. Maybe filing a suit to declare that this is agreement is not valid, something like that I'll have to do. So I have to go back to general law and look for my remedies there, because this law doesn't make any provision for my being able to challenge it. If I am a party, or if I'm interested, and someone else signs the settlement agreement as Chitra, that is impersonation, that is provided for. But there I am a party to the agreement, because Chitra is a party to that agreement. But a non-party, there is no provision in this law on what they can do about this agreement. Paragraph number 2, a mediated settlement agreement may be challenged only on all or any of the following grounds. So other than this, you don't have any possibility of challenging a mediated settlement agreement. This is exhaustive. This together with section 19, we'll come to it. The grounds are fraud, corruption, impersonation, and where the mediation was conducted in disputes or matters not fit for mediation under section 6. An application for challenging a mediated settlement agreement shall not be made after 90 days have elapsed from the date on which the party making that application has received the copy of the mediated settlement agreement under subsection 3 of section 19. That is the authenticated mediated settlement agreement. Provided that if the court or tribunal, as the case may be, is satisfied that the applicant was prevented by sufficient cause from making the application within the said period of 90 days, it may entertain the application within a further period of 90 days. So 90 days plus 90 days, you have to challenge it. There is nothing in this section that allows for a situation where I may not be in a position to challenge the agreement. Fraud is an example. If I'm still laboring under a misconception because of suppression of information or fraud, I may not know the truth or the reality of the situation in 90 plus 90 days. So if I find out something after 6 months or after 8 months, there's nothing I can do about it according to this law. Okay, so let's look at, we also go to section 19, and in section 19, if you can look at the explanation. Section 19 talks about how you need to, the procedural requirements for mediated settlement agreement. It includes an agreement in writing between some or all of the parties resulting from mediation, settling some or all of the disputes between such parties and authenticated by a mediator. Right? So, you don't need to have it in writing, but if you want to enforce it, if you want to challenge it, question it, you need this document to be able to do so. Provided that the terms of the mediated settlement agreement may extend beyond the disputes referred to mediation. Explanation. A mediated settlement agreement which is void under the Indian Contract Act shall not be deemed to be lawful settlement agreement within the meaning of mediated settlement agreement. So though this is not under section 28, it is covered here. And if it is a void agreement under the Contract Act, it's not a mediated settlement at all. But I think you will need to do something about it to make sure, and there is provision under the Specific Relief Act, where if there is a document or an agreement which is void or voidable, and if you feel that it can go against you, you can file a case in the court to get it cancelled. So there are provisions in the Specific Relief Act and the Contract Act for you to take action in respect of this. But because this explanation says it's not a mediated settlement agreement at all, you can't challenge it under section 28. You need to use some other way of attacking or neutralizing this document which can go against you. Now, what is void, right? So under the Indian Contract Act, we have two categories of situations when an agreement is formed. A lot of you are going to find what I'm going to say very basic and very something that you're very familiar with, but I'm just saying it for the purposes of completeness, because a lot of us in this group are not lawyers. Anil?
Madam, just one question, whether some party can give a power of attorney to other person to sign on his behalf the mediation agreement?
Yeah, if the law permits something like that to be done, yes.
But I think laws are silent. This mediation law, nothing is specific about it.
No, you don't need the Mediation Act to really talk about it, because other laws enable. The Contract Act itself, there is
power of attorney provision is there. It is a standard provision.
No, that is a Power of Attorney Act. I'm not talking about it. I'm talking about the law of agency.
But there also there is no mention that power of attorney can be given in respect of mediation.
Yeah, it's not going to say specifically, because once you start specifying that you can do it for this, you can do it for that, you can do it for the other, then the question comes up for the other situations that you've not provided for, what happens? So unless it is prohibited, you can authorize someone to do what you need to do.
Okay, thank you.
So, sorry, just give me a minute. Okay, I think let's stop. In the Contract Act, there are two yeah, Venkat Krishna.
Madam, we are talking about void and voidable agreements. When there is an settlement agreement going on, who is going to identify that? Whether the parties or the mediator?
It is the responsibility of the parties to identify it.
Not the responsibility of the mediator.
It's primarily the responsibility of the parties to identify it. If you place the responsibility on the mediator, there are many things that the mediator may not know.
Yes.
Right? If you find that it is something to do with money from money laundering or whatever, then yeah, you can flag it. But often you don't know. Right? So these two categories of agreements that the Contract Act talks about, that is at the time of formation, one is void agreements, the second are voidable contracts. And the Contract Act says that for any agreement to be enforceable, any agreement to be enforced under law, which is what a contract is, it needs to meet certain requirements at the time of formation of the contract. One is that it must be with the free consent of the parties. It must be an agreement that parties have capacity to enter into. So you exclude children automatically from formation of agreements. and it should be something where the agreement is lawful for a lawful object and a lawful consideration. Then these are the essential elements that an agreement must have. Now within this there are two categories. The first is an agreement is void if the person entering into an agreement, any one of them, does not have the capacity to enter into the agreement. So incapacity is minority, is also where the person is not what's the expression? The person is not mentally capable of entering into that agreement, of realizing the consequences of what signing such an agreement would, or entering into such an agreement would entail. It could be someone who is not constantly unwell, but is also has periods of time when they are unwell and periods of time when they are well. And if they enter into an agreement at the time when they are unwell, then it is a void agreement. So if you are inebriated, under the influence of alcohol, certain drugs, where you're not able to exercise your discretion, that's a situation where it can be void. Can you please give me just 2 minutes? Sorry. Then there are situations that the Contract Act talks about where if you make agreements in these certain situations, then it will be void. For instance, if you make an agreement restraining the ability of a person to go to court, it's void. If you make an agreement in restraint of trade, for instance, if you make an agreement with, say you have an agreement with Dhoni, where you say that you are going to advertise my products or you're going to endorse my products. And you say this agreement is for 3 years. And you say that after this 3 years, for the next 10 years, you will not make an endorsement for a similar company. That's void because you're restraining the ability of Dhoni to do trade. An agreement where your object is immoral or your consideration is immoral, what you're going to exchange, what you're going to do is immoral or against a law, that becomes a void agreement. So these are examples of agreement which I'm pulling up from the Contract Act, where a mediated settlement agreement will be void. You cannot go ahead with that settlement agreement. So a lot of the points that you all had raised against public policy, if what they're agreeing to is illegal, it's against the law, all of that will be covered by the explanation to Section 19, which will not have any effect at all. The next category of agreements which could be voidable at the time of formation are 4 types of situations. The first is if there's fraud, and fraud includes keeping silent on something when you have a responsibility to talk about it. Next, misrepresentation. Misrepresentation is something which is not as serious as fraud, but you have an idea about something. You don't intend to deceive the other person, but you don't share this information because of which the person is misled into believing a certain state of affairs. That's misrepresentation. The third is undue influence. And the fourth is coercion. So in these 4 situations, a party, these are called voidable contracts, which means that the contract is good if the party who's a victim to fraud, coercion, undue influence, or misrepresentation wants to continue with that contract, they can. But if they don't want to continue with the contract, they have the freedom. The law gives them the right to say, I don't want to continue with the contract. So these are voidable contracts. Now, out of this category of voidable contracts, we find fraud is recognized in Section 28 of the Mediation Act. But the other points that you all raised, silence about certain things, misrepresentation, undue influence, coercion, unconscionable agreements, these are all not covered as grounds where you can question the mediated settlement agreement. So this is broadly the law. Anil, sorry, you've had your hand raised for some time.
Madam, according to me, prima facie, the agreement should not be voidable or void. To ensure this is the primary responsibility of the mediator. Prima facie. He need not go into the deeper detail. If in detail it is examined, then it may be difficult for the mediator. But prima facie, the agreement which is signed by the mediator, it should not be void or voidable. This is my opinion.
Okay. My concern with something like that is that the mediator doesn't know the entirety of the situation. So to place this responsibility on the mediator is a little...
That is why I say prima facie.
Okay.
If apparently it is void or voidable, then why to go for such an agreement?
Right. So voidable not so much, but void
definitely.
yes. Yeah. Any other comments, any other thoughts on this? Anything that we discussed that was not covered in this? Change of circumstances not covered.
Ma'am, just one thing. Like we were going through this Ireland, no, I think it was Singapore law. There you have to go to the court to get it treated as a degree of court. Here in Indian context, it is just authenticated by the mediator and it becomes a degree of court. First thing. The second difference that I was noticing in this Ireland and this Singapore also, in both the laws, they are explaining and putting more focus on the agreement with respect to the contract agreement. In Indian scenario, they have just mentioned in the explanation that it should be only void word is used in context to the Indian Contract Act.
Yeah.
And I don't know whether all the paras of this Indian Contract Act will be applicable in this agreement also, like we are signing in this mediation, or just void part.
Only the void part will apply.
Only the void part. Okay. This is.
But if you look at Section 23 of the Contract Act, it can be either very wide or very narrow as the, as can be interpreted. One of the things we see in the Singapore Act and in the Ireland Act, which is missing in our law, is they look at certain specific circumstances and say, whereas in other situations this may be okay, in this situation or this type of dispute, there could be a problem. For instance, children, for instance, maintenance, for instance, family relations. They don't take a general view, they take a very specific view of how things should be done. Right? They recognize that there are certain categories of people who are vulnerable, and we are going to keep a wider eye about what are the agreements that are entered into in those contexts. It happened in Supreme Court in a case here in India where there was divorce between proceedings between a husband and a wife. The husband had initiated and the wife said, no, I don't want to give the divorce. And then it was sent for mediation, and she said, I do not agree to a divorce. There is no reason. I mean, she had her own reasons for it, but suddenly she agreed to it. And she said, and the husband said, I'm giving you 40 lakhs as compensation. She agreed to it and she signed, she said, yes, she signed the settlement agreement. When it went to the Supreme Court, they inquired and they found that the wife had found that she was suffering from cancer. She had no capacity to pay for the treatment. And so her only way out was to, or that's what she felt at that time. Imagine the stress she must have been under. She agreed to this because she can use the money for her treatment. And the Supreme Court said, this is not an agreement we will approve. But this is in a one-off situation, it is in a court annexed mediation when we know it is going back to the court for the court to give a decree. So we need to see how this is interpreted, how the law, when it is implemented, what are the sort of deficiencies that the courts are able to see in this law, and then see if there is something that needs to be corrected. Hemangi?
Ma'am, one question, how we could get such type of information from the parties that that particular agreement is void upon which the settlement is based upon? Because
No,
sometimes any of the party may not be aware of the law.
yeah, that's true. So one way in which this is ensured, for instance, under the Italian law, a mediated settlement agreement is enforceable as if it were a judgment. But one of the things that they do there is they say the lawyers for all parties must be present in the mediation at all times.
So it's the responsibility of the lawyers.
Yes. So this is one way of providing a safeguard that parties don't enter into agreements that are problematic.
Thank you.
Okay, if there is
two small questions, ma'am, just 2 points. Ma'am, reason behind referring the Ireland law by you. First thing. In Singapore, we are familiar then whenever these arbitration, mediation, these things are being discussed, the Singapore Act and somewhere it comes into the picture. Why Ireland you mentioned? First thing. Is there any specific issue that you wanted to highlight?
I have chosen, I typically refer to these, there are about 4 or 5 laws that I refer to. I choose the Ireland law because I find it's very wholesome in many ways. The law doesn't force mediation. Courts can refer parties to mediation, but what the law focuses on is giving information to parties about mediation. There is a lot of emphasis on the rights of parties. There's a lot of emphasis on mediator's conduct. There is a lot of emphasis on providing information to the parties about mediation before they look at mediation. So it's a very enabling law where the focus and the emphasis of the law is about the rights of parties. So that's why I like that law a lot. See, mediation is a private dispute resolution process. It happens behind closed doors. We don't know what happens, how it happens, where it happened. We don't know. But that law recognizes it. But look, when we saw this, it makes a provision for saying, I can question this in these circumstances. And it recognizes that there are certain vulnerable categories of people who typically may go for mediation because they don't have the stamina or the resources to go to court and fight a case. And it makes sure that when these people, this category of disadvantaged or oppressed people go in for mediation, that there is something that takes care of their rights and their interests in the settlement agreement. For me, that's very valuable. So that's why I refer to the Ireland. Second question.
Yeah, second one is, why I'm finding these mediation acts getting involved in 2015, 17, and recently in India 2023?
I'm not able to say actually. Sorry, I am able to say insofar as Ireland is concerned, there was the EU directive that I was talking about, which said make laws. So countries one by one started making the laws, and Ireland did it in 2017. Singapore, I'm not able to say why 2017. India, some of us had started work on a law in 2014. We felt that if we had a law in India, it would give a positive impact for mediation. It will give a lot of credibility to mediation. So we started working on this law, and then we shared it with the government. We shared it with the Supreme Court, and then the Supreme Court said, we think it's valuable, not the Supreme Court, but the Mediation and Conciliation Project Committee. They said, yeah, we think it's valuable to have this law. So they set up a committee of mediators, and we worked on the law and we shared it with the Supreme Court, which the Supreme Court then sent to the government. And it's broadly from that model. It's not the same, but it's broadly from that model that you have the Mediation Act 2023. A lot of things have changed in it. around that time, we also had the Singapore Convention. So when the Singapore Convention was passed by the United Nations General Assembly, it relates to enforcement of international mediated settlement agreements. So there was suddenly a lot of chatter and talk about mediation. And there was also the need for India to look at, our judicial system, because of the delays and things, it doesn't have a good reputation around the world. Maybe if we bring in mediation, a lot of the cases will be funneled out of the court system, and it will help us in our pendency. It's only the cases where the court, these are cases that the court itself has to deal with, like criminal cases, public interest cases, fundamental right cases, those kind of cases that the court should spend their time on. And we will be able to funnel out or divert some cases to mediation. That was the other thinking that was happening at that time. So I think all of this sort of worked for them to pass the law.
Thank you. Thank you very much.
Thanks. Krishna Kumar?
Madam, I think that mediated settlement agreement, they put the word Indian Contract Act 1972. That is the void agreements. They are putting that the void under the Indian Contract Act 1872. The Indian Contract Act 1872 has a very wide definition of void agreements. So I think they have put some restrictions on the mediated settlement agreement. So many restrictions will be there by putting only that Indian Contract Act 1872 void agreement. So it will be very difficult scenario actually.
Why will it be?
Because the definition of the void agreements is very wide actually.
Yes, it is.
It includes forbidden by law, any object or lawful object, unlawful consideration, unlawful objects,
yes,
injuries to persons, then immoral or opposed to public policy. This is a very wide range. So I think that they have contracted the mediation settlement act. It's my opinion actually.
Yeah. They have. So you don't have absolute freedom in what kind of contracts you enter into. But I think it's valuable. Because through a private settlement process, you should not be able to do anything that you want. There must be some responsibility on the parties on what kind of agreements they make.
Okay. Yes.
That's my view. Yeah. Kesha?
Ma'am, a little off-topic question for my help. Can an check bounce case under 138 be requested to be sent to mediation?
Yes, and it's being sent.
So for that, both of the parties should agree, or one party can propose and the court
One party can propose and the court can decide. Though it's not a civil matter that is covered by Section 89 of the Civil Procedure Code, it is being sent for mediation. In fact, there have been some problems that have arisen in terms of enforcement, where if you enter into a settlement agreement and typically it is about returning the money, and they enter into a settlement agreement and the complaint is closed and this person doesn't implement the settlement agreement, what can the other person do? That question has come up. The Kerala High Court has said we are giving these instructions to the magistrates where don't close the complaint. If they say they are going to pay in 6 months' time, you adjourn the case by 6 months to make sure that that payment has been made. So that's what the Kerala High Court said, and because this is the point that you're making. It's a criminal proceeding, but you're using a civil system for of court annexed mediation to settle it. The Delhi High Court said that again, a magistrate in Delhi had referred the question to the Delhi High Court, saying, how do we implement these things? So the Delhi High Court said, if you've closed the complaint, then you can recover it as a fine from the party. But the closure of the complaint on a settlement is actually an acquittal. It's a discharge. So you cannot impose a fine when the person's being discharged. So there's a problem with the Delhi High Court judgment. But typically they are sent, and just to complete what you are we are going to now talk about we're now going to talk about what are the cases that can be sent for mediation and cannot be sent for mediation. In that context, we'll come back to what you're raising, Keshav. But cases are typically sent, a lot of check bouncing cases are sent for mediation.
Thank you, ma'am.
Okay, so we'll start on the next topic, which is what are cases, are there cases that we think should not be sent for mediation? Are there any categories of disputes that we think should not go for mediation? Check bouncing cases, perhaps? Because it's an offense? Yeah, Hemangi?
Certain sorts of criminal cases cannot be sent to mediation. Such type of, say for example, dacoity or murder or like that.
Yeah, so serious criminal cases cannot be sent for, serious crimes or offenses cannot be sent for mediation. That's one. Anything else? Government disputes should not be sent for mediation. What do you all think? Can we say government disputes should not be sent for mediation, Kesha?
Ma'am, government disputes should be sent for mediation. Only subject to fact that the person representing government should not be corrupt.
Okay. How we do that, I don't know, but actually there is some mechanism, Keshav. We'll come to that immediately after we've completed this discussion.
Madam, dowry cases should not be sent for mediation.
Sorry, what cases?
Dowry cases. Asking money in marriage.
Yeah, you think the punishment should follow. So serious social offenses, you should not send for mediation. Because there is a policy behind it. I think this is what Anil is making up. There is a policy behind this that we want to eradicate a certain problem. We want to stop a certain problem, and we can't allow that to be settled. We need to send a message to society. Right, Anil? I'm putting words in your mouth. If this is not what you intended.
Same thing.
Okay.
But since it is not my field, I find it difficult to find the proper words.
Oh no, you find it very well. You're being modest. Arun?
We have a Conciliation Act, and therefore government disputes, they are otherwise also being mediated. The conciliator is nothing but a mediator. So government disputes are being referred and should be referred. Why not?
Okay. Yeah, Keshav?
Ma'am, just on a separate note where Anilji said respect to dowry cases, currently the situation is where there is a dispute in a marriage, the first thing the people from the wife's side they'll do is to file up a case for dowry. So logically, from even the courts now knows half of the cases are fake cases and it's just a pressure tactic that they're using. So why not have a mediation and get it settled?
Okay. Sorry, Venkatakrishnan?
Matters which are impacting the fundamental rights and impacting the constitution and sovereignty of a country cannot be mediated, is what I feel.
Okay. So if you go to the Ireland Act, that says that cases involving fundamental rights against the state should not be mediated. Hemangi?
Ma'am, subject related to public policy at large could not be also sent to mediation. So, for example, environment law or specifically something like that.
Sorry, what did you say? I couldn't follow.
Subject or matters related to public policy should not be sent for
What would
mediation.
that be?
The people at large or community at large, which are related topics, that could not be the subject matters of mediation.
Of mediation. Okay. So I'm going to, because we don't have too much time, I'm going to deal with two aspects of cases that you raised or I raised. First being, and what the Mediation Act says about it. So insofar as community mediation or matters that affect large groups of people are concerned, Hemangi, there is a provision in the Mediation Act that talks about community mediation. And the expression community mediation is a little vague. It talks about neighborhood disputes, it talks about disputes between communities, and it makes a provision for the district collector or the taluka or district legal services authority to form a panel of mediators. These are not trained mediators. These are people who are persons of standing and respect in the community. They will be put into this panel. Now, if there is a community dispute, it could be a neighborhood dispute, it could be an apartment complex dispute, it could be dispute between two communities, it could be dispute relating to grazing of land, right to water, it could be dispute relating to, say, right of certain group of people to do certain thing in a temple. Could be, the definition is not, definition is very loose. If such a dispute arises, and if any one of the parties to the dispute asks for mediation, they can ask the district magistrate or the legal services authority, and they will form a panel of mediators who will then mediate that dispute. If there is a settlement agreement in that dispute, that settlement agreement, unlike what we just read in section 28 now, will not be a decree of a court. It will just be a settlement agreement. And that's important to note. It's very important because you cannot give a rigidity to what the settlement agreement is saying. This is it, we will enforce it in this fashion, because for the same reasons that you pointed out that such disputes could not go for mediation. There needs to be a certain fluidity because the situation itself is fluid. There needs to be a certain flexibility about all of this. I understand that there are some rules being made about this community mediation, but we'll know in course of time. But the sections that deal with community mediation are sections 43 and 44 of the Mediation Act. So the attempt, because of concerns that made you say that this should not be taken for mediation, there is a separate framework for mediation that this law makes for community mediation. So 43(1) says, any dispute likely to affect peace, harmony, and tranquility amongst the residents or families of any area or locality may be settled through community mediation with prior mutual consent of the parties to the dispute. For the purposes of subsection 1, any of the parties shall make an application before the concerned authority constituted under the Legal Services Authorities Act 1987 or the district magistrate or subdivisional magistrate in an area where no such authority has been constituted for referring the dispute to mediation. In order to facilitate settlement of a dispute for which an application has been received, the concerned authority shall constitute a panel of 3 community mediators. For the purposes of this section, the authority or district magistrate or subdivisional magistrate, as the case may be, shall notify a permanent panel of community mediators which may be revised from time to time. The following persons may be included in the panel referred to in subsection 4. Person of standing and integrity who are respectable in the society. Any local person whose contribution to the society has been recognized. Representative of area or resident welfare associations. persons having experience in the field of mediation, and any other person deemed appropriate. While making a panel, the representation of women or any other class or category of persons may be considered. In section 44, procedure for community mediation. Any community mediation shall be conducted by the panel of 3 community mediators, referred to in subsection 3 of section 43, who shall devise suitable procedure for the purpose of resolving the dispute. This is really important. The community mediator shall endeavor to resolve disputes through community mediation and provide assistance to parties for resolving the disputes amicably. In every case where a settlement agreement is arrived at through community mediation under this Act, the same may be reduced into writing with the signature of the parties and authenticated by the community mediators, a copy of which is to be provided to the parties. And in case where no settlement agreement is arrived at, a non-settlement report may be submitted by the community mediators to the authority of the district magistrate and to the parties. Any settlement agreement arrived at under this chapter shall be for the purposes of maintaining the peace, harmony, and tranquility amongst the residents of families of any area or locality, but shall not be enforceable as a judgment or decree of a civil court. The provisions of section 20 shall mutatis mutandis apply in relation to the registration of the mediated settlement agreement under this section. If you want to, you can register. You don't want to, you need not register. That is section 20. So, there was something I wanted to say. So I'm not familiar with community disputes, disputes that happen in the villages between castes, communities. I think there are peace committees that are formed, a lot of things, but I'm not very familiar with this. I'm very narrow and urban in what I know. So I don't know how this that works, how that system is. Is that better than this? I'm not aware. How does this compare with Khap Panchayats? That's another question. So, one comparison that I'm aware of, I'm sorry to say that I'm making a comparison with something that happens in another country and not what is happening in our own country, which may be a better comparison, but just for information, after John F. Kennedy was killed and Lyndon Johnson became president, he signed into a law, a Civil Rights Justice Act. And under that, they have a community mediation program where the federal government has a group under a department, under the Department of Justice. They have a group of people who are trained mediators. And whenever there is any racial or community problem, people from this group rush to that area and they start working with the communities to try and diffuse the situation there. And they use mediation. They stay there for days, weeks, whatever it takes to help sort of diffuse the situation. So as an instance, when it was ordered that school buses will not be segregated, that all children will travel in buses. There was resistance by, of course, the oppressor community. They didn't want that to happen. So these mediators went there and they were there. They helped in, gradually implementing this in various places where there were problems about implementing it. So this is the work they've done. So I think one can draw comparisons with what is already there in place for community disputes in India. It's very, very pluralistic. It's not just peace committees and other things or Khap Panchayats or whatever, but there are many, many ways in which community issues are resolved. And I think one can compare what this framework is. There is very little that you can see in it, but there are certain important points that are there in this. I think it's a very bare bones thing because it's very complex, disputes like this. And so I am actually surprised to see something like this in this law, because there is so much more that is contextual. Again, retaining government control over how these disputes will be resolved, I'm not sure that's the right way, particularly if you're talking about a permanent panel of mediators and things. Each situation calls for its own type of response. So, but we need to see what the rules say, because I think that's where everything will be, right? So that's for community mediation. Insofar as disputes concerning the government, where the government is a party is concerned, we'll read the sections in the next class, but there's a very important move in this Mediation Act, and that you see in Section 2 of the Mediation Act itself, where it says that any disputes to which the government is, this law will apply to government disputes. That's a very powerful statement. It's not just disputes. So you have the government putting its weight behind this law and saying, oh, it's not just disputes that all of you may have with each other that can be mediated. Our disputes will also be mediated. So the kind of credibility that gives for the mediation process is very important. To start with, it will only be commercial disputes that the government has. But going forward, the government says we will extend it to other types of disputes. For instance, disputes with their employees. It could be disputes between, say, one department and another department, public sector undertaking and a government department. So it could extend to other areas, municipal corporations and the people for any projects or any development, any plans for the municipality or the panchayat. So these are areas where it can start moving out into. So we expand the scope of government disputes and mediation. There are two other points that are very important. This is a point Keshav made. He said we can have government disputes if the person, the bureaucrat concerned is honest. All right, but bureaucrats are actually afraid to use mediation because they feel that if I settle today, tomorrow someone's going to question me and say, how did you settle this? The claim that the government had was 100 crores, you've settled it for 70 crores, what about the 30 crores? How much did you take? Right? So one way in which the government is attempting to deal with this issue, and it's already there in the Act, is to say that when government disputes are resolved, the broad terms of settlement that are arrived into, that will be escalated to a higher officer who's not directly concerned with the dispute. Either an officer or a supervisory body within that government or that agency or the public sector undertaking, they will look at this agreement, they will vet this agreement and see if this is the best agreement that they can have in the circumstances. And if they approve of it, then it will proceed to signing. So you have a mechanism that can be inbuilt within the system to make sure that it is not one person who's taking a call on all of this, who will either be subject to criticism or subject to questions about the integrity of the settlement agreement. The second thing that the law says is that government agencies will also frame schemes for their individual agency or the PSU on how they will implement mediation for disputes that they have. So there are examples of this already. The NHAI, the Ministry of Road Transport and Highways, the Shipping Ministry, they have conciliation policies under which they have conciliators who they've appointed. These are persons of, these are conciliation committees. These are persons who are very senior accountants, retired bureaucrats, retired high court judges, subject matter experts who form a conciliation committee. They bring their experience in helping the parties, the government and either the concessionaire or the contractor, to resolve their dispute through a settlement. So all that experience, that wealth of experience that all these persons have, will help them in assessing and telling the people, these are your strengths, these are your weaknesses, this is a good way to settle this dispute, right? They're able to see and understand the dispute as well as the parties to the dispute. So that's another sort of point that is there in the Mediation Act. We'll read those sections when we meet next class. Krishna Kumar?
Madam, in Mumbai, there are so many big projects are going on. So what MMRDA has done, they had put in a contract a dispute resolution board. So when the dispute, so already they solve the disputes and then there is no need of going to arbitration. Only the disputes which remains, they go for arbitration. But
That's
at the
right.
very early stage, they solve it at the dispute resolution board.
That's right. So the other thing about that, Krishna Kumar, is thank you for bringing that up, because there the idea is that as and when some issue arises, we try and resolve it with this external agency, which is the dispute resolution board. So it doesn't escalate, doesn't become a big problem. We try and work it out. Yeah, that's right. A lot of people are, this dispute resolution board has been in vogue. It was there for several years. A lot of people don't have any confidence in it.
Yeah.
But that's actually a good way, because before it gets out of hand or gets more serious, we try and resolve it. Yeah.
That's true. Actually, dispute resolution board's decision, if it goes against the government gives dissatisfaction, notice of dissatisfaction, or in case it goes against the party, that is agency, then they go for notice of dispute, this thing. So it is only a intermediate level that has to be crossed before going to arbitration.
That's it.
So,
And it's not mediation as much as it's a decision given by the DRB.
Yes. Yes.
That's true. But it could be mediation, in which case then, they're able to bring more aspects to it on a confidential basis and try and resolve it. Yeah. Okay, we'll see you next week. Have a happy Sunday, all of you. Bye.
Thank you.
Thank you, ma'am.
Bye.
Thank you.
Thank you,
Thank
ma'am.
you, ma'am.
Thank you.
Very much. Thank you, madam.
Bye.
Thank you, ma'am.